Greetings to all loved ones. I just want to say thank you for everybody for attending tonight's event. And let me fast forward just a little bit. Check out Jody's program tomorrow in the kindergarten chat. This video, again, this is going to be a continuation of what are we putting in our cup? Whose cup is this? And why is this cup pretty important? She's going to touch again on chords and energetic attachments and all these things. These little spiritual tricks that we're learning to manage our state of affairs. Again, this isn't always just about paperwork and equitable words on paper. No, it's how we conduct ourselves out there. And that's why, like, again, literally, you know, I'm one of the big equity guys here. And yet I had to bow down and say, yeah, you know what? It's about 70% spirituality, 30% paperwork and knowledge of equity. It's literally that different. Now, again, I can lend a lot of attributes and a lot of experience and with Jody's presentations, of course. But at the same time, it literally is that important. That spiritual side, that component, that's what's going to keep us true. That's what's going to keep us on the narrow path. That's actually why we're all here. And this is why I'm asking, you know, that we always just spend a little bit of time trying to do a little bit better every day with us something. It doesn't matter what it is. Even if it's little, don't matter. It's the thought that counts. And if you happen to be able to do a little bit of faith with works, okay, now you're planting some serious seeds. And the powers that are out there, they are watching. They pay attention to every little thing we do, say, convey, type, post, all of it. Okay, crushing through this because we got a lot to cover. I got some good news. I got some other good news. And then I got some pretty good news. So the affidavit's pretty tight. It's wrapped up. So it's good to go. So is the petition. Here's where it gets to be, well, not bad news. They're still in the red versions. I haven't really had a chance to crayon these things yet. So these are going to be the raw, tough, hard to read. But again, it's very in line to what you've already been exposed to. So it's just a little bit more of it. It's not a whole bunch of other different words that are coming at you from right field. It's just a repetition of it, you know, of the bulk of what it is that we're trying to do here. I'm hoping by tomorrow, early, I'm going to say late morning, I should be able to streamline both of these and have a crayon version of them and have them posted as well. How I'm going to post them, we'll talk to the queens here and we'll see what's going to be the best method. Maybe we just shoot them right up on the Telegram chat rather than us doing it here. Because again, that's a pretty last minute thing. And I don't know what you're all doing at, you know, say 9:30 in the morning, 10 o'clock my time. So I think it would be just safer to say, just let me post it around that time. That's our plan-ish. Here's the rest of that. That's still pretty good news. The deed, I still didn't get quite to the deed to bring it in. Again, it's pretty much done as well. It's about at the 96% rate. Here's the thing, though, with the deed. All we have to do is reference the thing and suggest that it exists. We actually don't have to attach it right now. So we actually have a bit of a window. Bryce has a little bit of a window. Hey, master, if you really want to see the physical trust expression, just request it and I will be more than happy to provide it to you. So there's going to be a little bit of, you know, downtime there so that we can squeeze it in. Again, it's kind of strange how the timing of all this is just kind of all seems to be working. The affidavit, I added a number of components. Again, you're going to see because it's the red version. Don't let that scare you. Again, this is as hard as it gets. The petition, it's been pretty dialed in. Now, again, the point of these two documents is the petition's always talking about the affidavit, and the affidavit's talking a lot about the petition. These things kind of help each other create a something. Now, again, when that deed shows up as instrument number 3, that's what really locks this whole process down. And by the time we put some of these evidences into the possession of the court, it's going to really start to do some favorable things for us. So without further ado, let's just see if I can pull up. I'll start with the affidavit. So I guess what I'm going to try to do here, loved ones, is do the affidavit for, say, half of an hour of this class, this show. And then I'm going to pull up the petition. Oh, wait a minute. This is the petition. Hang on. Now I'm going to be challenged. Okay, how do I stop sharing this one? Okay, I'm going to stop sharing this one. Okay, and as luck would have it, guess what? I did have the right one up. My bad. Okay, trucking through. Again, Is this the first or the second affidavit according to whatever it is or wherever it is in your process, whatever you've done to date? If this is your fifth affidavit, that flies too. Okay, so again, I've made some changes, but here's the thing. This is all one color now. So we actually can't reference, okay, what is the newest upgrade? So we're literally now looking at the whole thing quick though. Again, posted at the end of the segment here. You'll have it for your consumption, so don't worry about catching it all right now. But again, so we're talking about an affidavit in support of a petition. Here's an addition, made at judge's chambers urgently. That's an important one. Notice of motion to declare titles, injunction, and appointments. This stayed the same, this stayed the same, that stayed the same. The petitioner, a party of record. I know that was an update from a couple of classes ago. The statements in my foregoing petition are made and are true of her own knowledge, or you could really say of my own knowledge there if you want. They really want us acting in or conveying this in first person, but yet we kind of bounce back and forth, oddly enough, in different segments here, and they still seem to be okay with it. So I think this opening statement here stayed the same. Oh, no, it didn't. Look at this. Okay, being of the age of majority, of course, I am duly present. I am able, ready, and willing to do anything equity requires of me. That is, again, opening the door for our whole equity plan here. That's why we're just kind of always dropping it consistently. We're always, anytime we have a little angle where we can drop a maximum or drop something in regards to an equitable remedy, boom, get on it. Okay, so and then look what this does right away. So now it goes to, and that you, any name such as a Crown attorney or a bank representative or a school board trustee or the Prime Minister of Canada, any name can go in here. So let's say for Bryce's story, for example, where he's rolling into court on Tuesday, if he wants, he has the option here to put the name of the Crown attorney right here. Because Bryce would now be coming forward and saying, and in fact, and indeed, duly named, you are duly nominated. You are duly elected and thereby duly appointed to undertake a portion of the trusteeship of whatever all caps name it is you have for the purposes of trust, respecting this and any other matter as relates to the trust, as so directed by the court. Okay, so I added this little line here. You will now duly notice by my own devise, and you now being duly bound thereto, the Trustee Act, and now you have knowledge of my expressed trust, and as such, your duties to act are being called upon by the affiant herein. I probably should have here you could put the petitioners, or you could literally say my truths if you wanted right here. And you will called upon about okay, I gotta tweak that. That didn't quite make sense. By the affiant petitioners truths. You know what? Just take that right out. Being called by the affiant herein, and you will understand, right? Because we all kind of sort of know what that term means now that we've had a few years to experience the bad end of the stick. You will understand, Mr. Attorney, Mr. Bank Representative, Mr. whoever you are in your official capacity. You will have knowledge of what I believe. These rights, and this is how I think things should shake down. Now, again, there's a lot of equity mixed into here. That I didn't change. That was still from yesterday, so that you just roll with that one. So that subsequent to events having occurred on or about the day you were born, whenever that was, stick the date in there, and by information duly provided by my parents, their names, certain interests were granted or delivered to the province or the state for the strict purposes of registration. That was the only reason they did it. And there exists a particular certificated security in registered form. That's a whole bunch of garbly goop to say the birth certificate. Registered on the date of, put the date in there, and subsequently issued on, because a lot of times they issue it on a different date that it's registered. If those happen to be the same dates, let it rip, doesn't matter. Evidencing said event. And now that I assert subsequently to my parents' ignorance of the requirements under law or equity, or of them having little or no knowledge or understanding of the peculiar nature and character, there, that's two capacities right there, by the way, of this particular transaction, otherwise known as the birth event, the informants, mom and dad, failed to avail my rights as an infant. The parents, or my parents, having not expressed any agreement or terms or trust duties by appointment or otherwise, abandoned any and all interest in said certificated security in registered form. Now that I come forward, or I come now to avail myself of any and all forfeitures or abandoned interests in the equitable interest. Now, again, when we're talking about forfeitures here, that is a very encompassing word because we're literally relying on a maxim here in the background that says equity actually hates all forfeitures. Equity abhors a forfeiture. So we're literally leaning on that maxim right there by coming forward now and saying, hey, I got a problem with a forfeiture. And to put directly into the possession of the appropriate party, the respondent or the defendant or whoever it is you're naming as the duly nominated trustee, that the same security interest once attached to me as surety of, and as a result of no certain disposition on my part having ever occurred on my behalf until now, and that I know and assert I accepted possession of the said certificated security as grantee. And that interest has been in my sole possession since I was approximately 16 years old. And my parents, acting on my behalf, also put me into direct possession of that says security, certificated security, chattels real, personal property. We can play with some terms here. When I was a minor, and I had no business or knowledge of such agreements, and thereby my parents instructed me to act as and for this person. And by making voluntary application for a, you could literally put, instead of putting a social insurance number there, you could literally put like a tax identifier number. Again, this is all having to do with taxation. Again, so at the age of 16-ish, I admit was a mistake. What I did when I was 16, I'm admitting now that was a mistake, an error or fraud. And I am come quickly in good faith to petition the court and have that particular legal title vested in new trustees, where based on my contribution, I have purchased and parted with value to acquire the whole title as relates to the name and estate of your all caps. I am exercising my inherent right, coupled with an interest, to be heard at a court of conscience. You could put Judge's Chambers in there if you want. For redress, complete justice, and I believe, based on the information to be true, and given the character in possession of the court, and specially deposited or paid into the court, this warrants the court and empowers it to take jurisdiction to avoid a multiplicity of suits and decree or order the relief prayed for by me, the petitioner. The source of this information is equity will not suffer a wrong to be without a remedy. There. See how you actually used a maxim as a source of information? That's pretty sneaky. I like that one. And that I am the surety, among other sureties, and I was formerly possessed of a legal character and the accompanying interest that went with it. And due to an event at my birth, and that subsequent to its perfection now, made on or about the day of, whenever you perfected your certificate, your security, whatever that is, and if you haven't done it yet, right, that'll be a date here coming up in the future. And that the particular legal title now merged not only at law, now you're satisfying some of the legal requirements when you actually say that, and how it ought to vest in new trustees. And I believe this petition brought to the attention of the clerk and master or the judge at chambers, take your pick. They're both going to be effective. So if Bryce is dealing with the judge right now, he might want to just throw it into that same judge. Or you could say to the clerk and master in reference to this other judge. So now you're kind of dealing with all of the marbles, and between those two parties, the right one is going to get it. And so brought to the attention of the clerk and master ought to furnish due process to issue. That means start stamping stuff. start processing my paperwork, start receiving, start doing, acting properly. And the reliefs ought to issue as a result. There's an important word. That means something has happened. Again, we are creating a resulting trust, giving it to the judge or the master so that they can declare or order or decree a constructive trust. They're the ones that construct it. We just show up with the wood and the nails, the substance. Expressed to the best of my abilities. Look at this one. Et al. That means, Your Honor, I've built this to the best of my abilities and maybe with the help of a few other people. And that the petitioners, you, are seeking the following orders and reliefs under Section 37 of the Law and Equity Act, vesting orders, where the court has authority to order the execution of a deed, a conveyance, a contract, a transfer, or assignment of any property or any other document, or to endorse any negotiable instrument. Remember that birth certificate qualifies as a negotiable instrument. The court may, by order, vest the property in the person and in the manner for the estates as would be done by that deed, conveyance, contract, assignment, transfer, or if it were executed, if it had already been executed. So they're just, it's kind of neat, how they kind of, you got to prove something exists and then claim it, or claim an interest in it, or express some type of privity to it, some type of relation to this event. It's this 1, 2, 3 thing that we're always having to fall back on. The court is in possession of securities paid into court and is warranted thereby. Now, okay, this version right here in the affidavit, again, they got all these blank spaces on the petition. I have this whole thing cut and pasted, dropped into the petition word for word, but I got all these spaces filled in. So hold on tight, that's coming. Again, nothing really changed here, except for this right at the end. That the said express trust left the land totally charged, or I have this written in the petition, or partially charged. Again, depending on what you're doing. In Bryce's scenario, where he's rolling into court dealing with the Crown Attorney, he may want to vest the entire 100% undivided interest in that thing to the Crown Attorney right now. Let's pretend you don't have a court case on the go. Let's pretend you want to assign a portion of your estate to a particular lawyer just to conduct some transactions for you and help ram all that through. You may not want to assign everything to this particular trustee until you get to know this guy or girl a little bit. Again, it's a bit of a crapshoot there. We're hoping that these trustees are going to act in good faith, and this is why we're bringing the courts in, because it's like once every 6 months or once a year or something like this, the trustees have to account for every penny, every transaction, everything, every charge, every fee, every payment. All that is tallied up and shown to you so that they can't hide. They can't do mischievous things. Continuing, I don't think I added anything here. So this would all have been the same, I think. Yeah. I think this was in here. I'm just going to say it anyway, though, because it's a nice one. That as a consequence of such facts, party A or you ought to exercise your right, or my right, as surety, who discharges liability entitled to assignment of securities, and thereby duly exercises this particular discharge, and that such an equity does exist, and that I'm entitled to it, and now I come, and now I claim such an equity. The judges like these types of words. And that party A, okay, wait, I don't think I dropped anything new into here. That should have been the same as before. So again, what did I do there? Okay. Now again, this is just particular to something that Jody and I are spinning, where we're taking a mortgage or a big loan that was paid off. Now that it's paid off, it can be discharged. Now that it's discharged, you can express your equitable entitlement to that note, because that note is still floating around in commerce land. They get to flip it up to like 23 times. Well, I've seen mortgage notes with bank teller stamps from all over the world.
Why the hell would a mortgage being developed in Canada, why would that wind up in Indonesia for some reason? Like, that's, I don't know, it's kind of strange. But again, this is how the commercial system operates. So do you have to put an amount here? No, I'm suggesting that Bryce wouldn't even put this in here. Take this right out. Or unless you want to say something like, okay, I'm going to take it, I'm going to tweak this and suggest any funds, any fees, any costs, any debts associated to this lawsuit or this motion or whatever this legal proceeding is that I'm dealing with, I'm just instructing the court, or I'm authorizing this bond will cover it. Whatever that number is. You just leave it blank. It's an option. The judge could actually tell you to fill in, and if it's something or other. And again, we had another gentleman friend in Saskatchewan who, how long ago? This was about 10 years ago. He was shooting some bonds out, and he was a farmer back in the day, and he literally sent out a number of bonds to like farming implement dealers. And all of a sudden, within the course of a week, he had like 6 brand new combines show up in his yard. RCMP show up about a month or two later trying to confiscate all this stuff. And then they actually try to get the implement dealers to charge this guy with fraud. And the implement dealers were like, well, we can't charge him with fraud because we got paid. So again, this gentleman back in the day, 10 years ago, we didn't have a sniff of this newer version of our information. So we were still able to get stuff done in an odd sense. We still were able to express enough equities back in the day. Great. Okay. So here's another part that has been added in, that the duly appointed express trustee may consider the above appointment having been granted the power of sale and proper indemnity provided under the Trustee Act. Again, indemnification for these characters, that's like a protective bubble. That's suggesting as long as you do your job, you'll be fine. Come with clean hands, act in good faith. Don't be a shyster. Don't try to screw us. Because if you get busted for breach of trust, you could be going to jail for a while. They take it pretty seriously here in the equitable side of the fence. And this is interesting here. This is an addition that it is possible to ascertain the beneficial owners of the trust. See, we just suggested that they exist. We didn't actually name them yet. No, let's actually get the judge to agree to all of this first. And then if he needs satisfaction, he'll say, well, who are the specified beneficiaries of this trust? If you get that far, trust me, you are one sentence away from glory. Now, who would be the specified beneficiaries of the trust? Well, Your Honor, let's start with myself. And then I'm going to pass a certain amount of interest to my spouse. And then upon my death or my spouse's death, I would like to leave X amount of interest to my children when they attain the age of majority. The terms and the terms of the contract or the agreement now that you have with whoever it is that you want to leave something to. Maybe you want to leave $1 million to the Humane Society so that they can look after the dogs and cats or whatever. You can actually stipulate that stuff. You can literally do it on the fly. You don't have to have all this stuff in writing, but I'm suggesting have a fair bit of it in writing. And pick your top handful of things that you would want to do and have that on a whole little separate piece of paper, almost on standby. So that if the judge asks you, you can say, Your Honor, I thought that you might ask me that. So here, boom, look what I got. And then you're prepared. Affiant further saith not. What does that mean? That means you've kind of said just about everything you need to regards to this affidavit to get this ball rolling. So how many pages was that? I mean, that's what, 4-ish, 5-ish pages. Can we tighten that up? Yeah, we can crayon this a little bit because, again, this is a lot of heavy language. This is a lot of just nuts and bolts. This is a lot of the stuff that the judge wants to see, though. However, a judge in Alberta here in Canada said not that long ago, it's not the fancy language that gets the job done. It's the clarity. So I'm going to encourage you, loved ones, to go read this stuff and just get your head wrapped around it as best you can. And then you crayon it. See what you can come up with. And when you come up to it, Darren, I didn't know really what to put here. What should I put here? Just leave that, highlight that so we can come back to that in a question. But let's just see what you folks can do with some of this stuff. If you wind up shrinking it substantially, hey, great. And this way you can still literally roll into court with this version in your back pocket. so that if your crayon version, if your number 2 here doesn't quite get the job done and the judge asks you, could you just provide a little more clarity with your statement regarding number 2? What did you mean by when the trustees duly nominated and duly elected? What's that all about? You could literally say, well, hang on, I got to pull up this other little piece of paper here. Okay, duly elected. Okay, that means this, Your Honor. Duly appointed means this, Your Honor. You can wing it on the fly. Just give me a moment, Your Honor. I got to check my glossary here that Dïevergent has happily provided me with as part of the others that I've been working with to develop this whole crazy thing. So there you go. This in itself is going to get some serious stuff moving for you in terms of an affidavit in support of a petition made at judges' chambers urgently. Okay, what is judges' chambers urgently? That is going to be talked about in the petition. Coming up next, let's see, we got a couple minutes we can kick around here. In judges' chambers, urgent says something to this effect, where the motion or the application or the petition is brought for urgent matters. All court rules and all court timelines do not apply anymore. I love ripping that one through my mind, because that's literally parting the Red Sea for you. Hey, doesn't matter what's going on over there. You got priority. You got priority over the entire public. Again, some of our colleague in the United States, he's taken students from 0 to the Supreme Court of the United States within 1 week. They went to the circuit court, then they went to some other court, and then they wound up at the Supreme Court of the United States within 7 days. A lawyer typically takes up to 2 years to get their motions heard at the Supreme Court. So there you go. That's the difference of priority. That's crazy. Awesome. Fast. Okay. I think we can put this one aside for now. So I'm going to stop sharing this one. Again, we'll post this at the end so everybody has it. Okay. Let's see if I can find. Of course, I can't find it. How do I find it? I have to change the tab again with that thing again. All right, let's see. Or like just quickly up. Yes. Okay.
And you're good to go.
Okay, I'll get this tab thing figured out. Okay, here comes the petition. Okay, now, just for the sake of argument, I got a couple of things in here. And then as this petition develops, I start talking about his or her. So I kind of just made it, like generic, so that you can just kind of pick through it and determine what it is you're trying to do. But you know how we're always trying to come in our duality now all of a sudden, right? Okay, here's my duality. This is actually what it looks like. There, that's my name on my birth certificate. Murray was my mom's brother who died when he was 2 years old, and Murphy was my grandma's maiden name. So there you go. There's the life history. But you see, okay, we got the person here, and we got the guy over here. Now there's 2 capacities right there. I could probably, if I really wanted to get creative, I could probably even put "and also known as" or AKA Darren Servant King of the North. Yeah, I could probably put that one in there. But you know what? I don't want to throw too much weirdness at them right now. Let's get in there and let's get something effected. Let's get something achieved. We can always come back and tweak and adjust and amend later. That's no problem. But let's just get our foot in the door here. Okay, and again, as I mentioned the other day, if you want to bring this claim against the public guardian and trustee, that's a fantastic place to start. If you don't want to do that, put Jane and John Doe here. And the clerk is going to take your paperwork anyway. But then he or she or the judge or the master is going to come back to you later and say, okay, here's who you should send your notice to: the public guardian and trustee, or the attorney general, or the deputy attorney general, or whoever it is. The court, the judiciary will actually tell you who you have to send your notice to. And he'll actually say, I'm going to suggest you got 21 days to get this done. Where you're going to be like, shit, no way, man, I'm going to get this done tomorrow, because you're super excited to get this before and get it going. Okay, so here's just all the normal nuts and bolts that they're looking for on notice to. Okay, so if you are sending it to the public guardian and trustee,
go find that address, wherever it is for your neck of the woods. Continuing. It just goes on, and now it wants your address. So again, I know we talked a little bit about envelopes there a week or so ago. We can touch again on that one tomorrow morning if need be. But again, you can literally just copy where I had that envelope posted from Gibson's book. Copy that. Make that one your default, because that one's pretty dialed. That one's like right on the money. So go ahead and use that one. Okay, so here we go. Orders sought. Ready? First of all, we're looking for orders made at chambers, injunctions in behalf of sureties, urgent circumstances under Court Rule 2219. That's the court rule that says, hey, if you got an urgent matter, bring it to judges' chambers and we can hear it without normal court rules and normal court procedure, and we can ram your stuff through right away. Where the petitioner claims against the public guardian and trustee, the respondent, and to be entitled thereby, entitled in trust, to an equitable estate or right, or to relief on an equitable ground against a deed, and orders ought to issue out of and under the seal of the honorable court made under the urgent nature of your petitioner's case. The court is warranted to grant the reliefs unto the petitioner duly prayed for. And where it is possible, an order may issue, and upon the proof submitted to the court that certainty of titles exists, purchased, and certain bona fide claims to those titles have arisen in equity. And attached hereto this petition is my affidavit in support of my pleadings bearing the date. Put the exact same date as your affidavit. If you get this wrong, it can actually cause problems. I would, we could probably also even include right here, and attached here to this petition is my affidavit. Let's put with schedules and exhibits. And you could and attached here to is a schedule and exhibits. And here's where we enter the deed that we don't quite have finished. And in reference thereto, deed in trust. Now, if you want, right here, you could probably put made on or about. If you want to add the date that you actually created that deed in trust, go ahead. So this is supporting all your equitable pleadings that we're making on the date here. Whereas, you notice how, look at this. You notice how we go from like where. So where there is something, now whereas. And where, and then whereas. Kind of bouncing back and forth. Kind of, again, establish a something, then claim a something. Establish a something, then claim a something. It's kind of hopscotch this thing a little bit. Again, these are just these little technicality, refinement type things that if you didn't do this, would your case be fatal? No. It's just little subtleties that the judges and they are going to look at and go, okay, yeah, they sort of know what they're doing. Whereas better claims for those particular titles are made in keeping with equity, evidencing the interests and claims made thereto in good faith, good conscience, and good reason, which results, there's that word again, and springs, there's that other good one, from your petitioner's equitable pleadings made under the authority of the Law and Equity Act, chapter whatever, sections, all the meat and potatoes that we're going to talk about here in a second. The orders ought to issue in favor of the petitioner, given the securities paid into court, evidences, facts, equitable pleadings. You could probably even put testimony of the petitioner or of me or of the SEDIC AV or whatever. You got some flexibility here. Where it appeared to the court no other party has a prior, equal, or superior claim to the rights and entitlements claimed by the petitioner. And whereas it appeared unlikely that another party could rightfully have a prior equal or superior claim to the same particular rights of dominion. Oh, there you slipped it in. Right there. Attached to the collateral and subject matter of the case provided to the court. And where it was found that proper trust relations exist. Remember, the courts find things. It's like you take a bag or a box or a package or a parcel, you send it to the court and they open it up and go, whoa, what did we find in here? You'll notice that the courts are always, and we, the court, find the defendant guilty or find the defendant not guilty. They're always finding. It's almost like they're always on these little treasure trails and treasure hunts. So give them things to find. Where was I? Where it was found proper trust relations exist respecting the parties to the suit and regarding the particular subject matter of the case. And whereas the parties involved ought to be put into the direct possession or the direct control of the respective rights and corresponding duties touching and concerning the parties, given the disposition of the perfected interests in the petitioner and made in favor of the respondents. So again, you're going to get some rights, they're going to get some duties. Each party gets something. Yay! Happiness, and they all cheered. Number 8, where it urgently appears just, convenient, and necessary to grant the orders under the authority of the Law and Equity Act for the reliefs prayed for, both generally and specially in nature. You could probably put it and in character here if you want. And where it is hereby ordered by the court. So what we did here, notice they wanted to know what orders are we seeking. Okay, so we spend about a page setting the stage. We're not really talking about orders yet. We're talking about what ought to order, what ought to order, what ought to order. And now all of a sudden, okay, where it appears to the court, or where it is now hereby ordered by the court, because it has knowledge of all the stuff above. Once the court can see all that meat and potatoes above, now it can come forward and say, well, where it is hereby ordered by the court that in all suits concerning real estate, which is vested in trustees by devise, and such trustees are competent to sell and give discharges for the proceeds of the sale and for the rents and profits of the estate, such trustees shall represent the individuals beneficially interested in the estate, or the proceeds or the rents and profits in the same manner and to the same extent as executors or administrators in suits concerning personal estates represent the individual beneficially interested in such personal estate. I know that was a whole bunch of meat and potatoes. A lot going on there. That's not my wording. That's a chunk of legislation I just grabbed there. That's one of the meaty ones out of the Law and Equity Act. Where it appeared before the court as a result of the petitioner's claims to be entitled in trust to an equitable estate or a right to relief on an equitable ground against a deed. They've got the deed. You're talking about it in the affidavit. You're bringing it to his attention or her attention right now in your petition. The deed's also going to reference it. So that's look at how many times we got to talk about the same thing here. Whereas it appeared the court has authority to order the execution of a deed pursuant to Clause 37 of the Law and Equity Act. And whereas it appeared to the court the right of equitable relief in the petitioner pursuant to Clause number 4 of the same Law and Equity Act. And where it also appeared to the court, you, a surety who discharges liability, is entitled to assignment of securities. If you want, you could right there say pursuant to clause, I believe that one was 34. The Law and Equity Act. Oops. And okay, someone was mentioning the other day, I saw in the chat, why do we put stuff in italics? Italics is just kind of bringing your attention to a certain something. It's just kind of bringing some emphasis. It's just kind of trying to set this little thing apart so that it stands out a little bit more. Essentially, that's really all it's really doing. Yeah, sure, we'll do that. Okay, now you're going to see some yellow stuff coming here in a second, but where it appeared to the court necessary to grant the orders under the authority of the Law and Equity Act, again, in favor of the petitioner who is or the petitioner seeking the following orders under Section 34 of the Law and Equity Act. Surety who discharges liability, as I just mentioned. Okay, so here's where your relief is in these 3 blue sentences here. This is actually the legislation. This is actually the wording. I highlighted it because I just wanted you to see it. You don't have to include this. The clerk is going to go, well, what the hell is Section 34 all about? I haven't come across that one in a long time. And she's going to go in the back, and they're going to read it, and they're actually going to go read all this stuff. So if you want to do them a bit of a favor, yeah, well, just include it. Every person who being surety for the debt, that means anyone who volunteered to be a debtor, all of us, a debtor for another individual, thereby being liable to that other individual. And if you pay any debt or pay any performance, or if you do anything you were supposed to do, you're entitled to have a trustee assigned to your trust, or for any judgment or specialty or other security that is held by the creditor in respect of the debt or duty. That's all pretty good stuff, actually. Continuing. The person who has paid the debt or performance, the duty, is entitled to stand in the place of the creditor. Once you pay the debt, you now get to stand in the place of the creditor. You know how the crown's always, or the state is always coming back, or they're always coming at us for something? That's them acting as creditor. So when you subrogate and now you stand in their position, are you not the state? Are you not the crown? Yeah, we literally are. The crown has all the power. We kind of want to be the crown again. But this time it's not one made out of thorns. This one's all rainbows and unicorns. This is the one we're after. In order to obtain from the principal debtor or the co-surety, co-contractor, or co-debtor, again, that's the state. That's the crown. And for any advances made and losses sustained to or for the person and performances, the surety is not pleadable in bar, which means that they can't basically bring an action against you for anything once you do this. Number 3, this should be over here. The co-surety, co-contractor, all that, and the other, is not allowed to recover from any other co-surety, co-contractor, or co-debtor by means referred to in subsections above, more than the just proportion to which, as between those parties themselves, the other co-surety is justly liable. What? That's another fancy just way of saying, hey, once you show up with a silver coin, boom, they can't operate in silver coins. So all they can do now is let you use all the cars and trucks and houses and boats and helicopters and everything it is that you need to go make this world a better place. That's all they can give us. Great, we'll take that. It's better than a kick in the junk. Number 14, where it appeared to the court necessary and convenient to grant the orders under the authority, again, of the Law and Equity Act in favor of the petitioner who was seeking the following orders under Section 37 this time. Section 37 is talking about vesting orders. So here it is again. I put the exact legislation in here in yellow. If you want to shrink your paperwork, just take out all these yellow sections, but have a copy of it for you so that if the clerk says, I don't know what you mean by vesting orders, you can say, well, according to Section 2, it says right here, an order made under subsection 1 has the same effect as if the legal or other estate or interest in the property had actually been conveyed by the deed or otherwise for the same estate or interest to the person or the trustee for whom it was ordered to be vested in. We show up with a private appointment, say, hey, Sally Sue, Mrs. Trustee, I duly elect, duly nominate, duly name, duly appoint you to be my duly expressed trustee. If they say, no, I don't want to do it, now you can go to the court, which is what we're doing right here, and say, hey, that trustee ought to perform, Your Honor. Why? A, no trust can fail for want of trustee, but if
Susie Q here doesn't want to do it. Well, then I guess the court's going to have to appoint a new trustee for it, right? Thank you. We're literally opening the door so that the judge can help us here. It is also hereby ordered that in virtue of Clause 39 of the same Law and Equity Act, that this injunction or mandamus or a receiver may be appointed by an interlocutory order. You just opened the door there for the judge to do these things. He can now say, thank you for granting me the power under the authority of these such and such acts to do this for you. You see how literally we show up with a gift to take the bond off of the judge as well? It's almost like the judge can't help us because he's kind of seized. He's kind of stuck in legal world. We got to give him something so that he can get out and help us. So again, just more meat and potatoes about what the injunction looks like and why it's appointed by an interlocutory order and how, see again, in cases in which it appears. That's why, as earlier in the petition here, where it appears to the court, as it appears, so it appeared. Apparently, this thing has to appear so that the court can actually work on it and do stuff with it. So it's good stuff to have here. It is hereby ordered that in virtue of Clause 11 of the same Act, equitable waste, respecting an estate for life without impeachment of waste, does not confer and is not deemed to have conferred on the tenant for life a legal right to commit equitable waste unless and except where an intention to confer that right did expressly appear herein by these instruments creating the estate. I'm going to say or trust. Factual basis. Okay. Where an affidavit in support of your notice of your petitioner's title and demonstrating a conflict with the rules at law, where it is appropriate to state here, the affidavit in support of a right of declaration of title between the parties, a right to an injunction, and a right to exoneration on contribution exists. You just said these rights exist. Why? Because of all that shit we just talked about for the last hour. And manifestly shows unto your honor that, and be it known, these statements, each supplying such a chief fact as together with others demonstrates a present, sufficient, perfect title in the petitioner, so that the court is warranted from the present force and completeness of his or her title to take it upon itself, the court, to enter into his or her case to see if she or he can have the relief she or he prays for by her or his petition. And the relief is sought as heir. That's a big one. These sufficient facts by statement demonstrate the petitioner to be the heir and manifests equities sufficient to warrant such relief being granted to him or her or you as he or she claims as by the heir through this petition, where your petitioner is the surety with the crown as the co-surety, and for the whole amount of the crown's liability, I'm coming forward now and inducing the court to cause the co-surety, them, the crown, to contribute its due portion of the liability. And this statement manifests an equity to exist as to the petitioner, and the petitioner is entitled to it, and now he or she claims such an equity. Oh, that is a heavy paragraph. You just got, I'm going to say 50% of the job done with that. That was a big deal. Continuing, thus your petitioner further shows unto your honor that he or she is coming now as surety on a note or bond filed in this special case. And this statement manifests an equity to exist as to the petitioner, and the petitioner is entitled to it now that he or she claims such an equity. See, we keep repeating that. Every time we drop a statement of interest, every time we drop one of those buckets of gold above, you got to claim the equity in it. Here's another dynamite one. And moving forward, that your petitioner further shows unto your honor that he or she requires of the court to undertake to distribute the assets among those lawfully entitled to share in the distribution. And this statement manifests an equity to exist as to the petitioner, and the petitioner is entitled to it, and now he or she claims such an equity. That your petitioner further shows unto your honor, this part, therefore, shows how the petitioner is in possession of the peculiar legal character mentioned in the introduction, namely, here we go, that by a bond, your birth certificate duly sealed and executed on and dated the date you did it, whereof the condition was perfected. Your petitioner became the creditor of the said life estate, and this part carries out the petitioner's title. Thus, he or she claims as heir that, put your name here. I'm going to say put your name styled properly. Don't put the all caps there, because this is you now coming as the man or woman. We've kind of already dealt with, we've kind of already disposed of the legal guy. So we're actually not going to really ever say that we are this legal all caps thing ever again. It's already kind of happened. And this part carries out the petitioner's title, honor about the day that you did it in the year of our Lord, was seized of and entitled to certain lands. If you want to put, you could put rights, you could put liberties, you could put incorporeal hereditaments. See where I'm going with that? We got some options here. Let her rip. Situate or situated in the province or state, again, wherever that birth certificate was issued. I'm going to suggest now that that birth certificate, if you're no longer living in the state you were born in, go ahead now and just state that. The certificate, although I was born in Arizona, I'm situated now in New York. See the difference? It's where that thing is right now, currently. So get that one dropped. Known as chattels real or personal property, that the said trustee, put the trustee name here, whoever it is you're appointing. I would put the duly, put their name in all caps and do it, style it normally, properly. That way you just captured them in their dualities. You captured the man and you captured their person. You got them both. Okay. That this individual, this person, was seized of a portion. Again, as I mentioned in the with reference to the affidavit. If you're only dealing with a portion of your life estate with this particular set of whatever it is you're dealing with, identify this or list this right now as just a portion. If you were bringing your cause to wind up the whole interest and you wanted to grant or distribute or donate or gift or assign or convey or deliver the whole interest to this particular lawyer or this particular attorney general, put that. It's either a portion or the whole thing, depending on which it is you're trying to do. You got the option. Okay, where was I? Seized of a portion or the whole legal interest per appointment duly made on the day of, again, whenever you dropped this hot potato into the lawyer's lap in the year of our Lord, that the said, here you go, your name's style proper, previous to his or her disposition of a security interest made and intended to create a trust. That is one of the 4 components to creating a trust. You got to express the intent to create. The settlor literally has to express it. He literally has to say it. I should literally put the word settlor in here, to be honest with you. So we'll do right here. As settlor. Made and intended to create a trust. Bearing the date, again, the date you did it, which was duly attested as to by the requirements of the law and has been duly proved by the statements herein and this affidavit, and attached thereto some exhibits and schedules and things marked A1 and A2. Again, we got some stuff rolling around here. I also did not get the schedules done for tonight, so I'm going to punch that out for you guys first thing in the morning now that I'm just looking at it. But again, super simple. It's literally at the top of the page, schedule. marked A1, number 1, an affidavit dated, made by, for the purposes and the intent of. Number 2, adverse claim made by this guy on this date for the purposes of. Number 3, deed in trust made by this guy on this date for these intents and purposes. That's all the schedule is, believe it or not. That's all it is. It's literally that simple. And that the said express trust left the personal estate totally charged, again, or partially. If you're dealing with the whole thing, it's totally charged. If you're only dealing with a portion of it, then it's only partially charged, depending on what we're doing. And resulted by the devise and charge and affected being to the effect of titles and rights and interests and duties ought to vest in the parties equitably, exemplifying of what security interest the petitioner was possessed, and how the petitioner is heir. And this statement manifests an equity to exist to the petitioner, and this petitioner is entitled to it. Now he or she claims such an equity. Boom. Right? You just grabbed it, literally. Now, no other man or woman now can come along and bump you or say, haha, you're crazy. You're not going to get this to work. Wrong. There's so many layers going on. I know it's hard to get the wheels spinning around this. There's a lot to it, I know. But again, this is why we're going to crayon this tomorrow. We're going to get this simplified. We're going to keep working with this. Bryce has been around the block a few times, though. He's got some pretty dynamite paperwork working for him in the background. So this is actually just going to kind of keep in line with everything else he's already got going. If he were to just show up on Tuesday with an incredibly crayon version of this, the judge is going to be like, you got a whole bunch of technical shit here, and then you showed up with a crayon version. Which is it? So Bryce should be incorporating a lot of this meat. And again, here's the beautiful thing. You walk into court with copies of this stuff, my loved ones. You can literally read this word for word onto the record. It's okay. I know I'm explaining it as I go, but literally, how long would it take you to read your statement here, your testimony? What, 5 minutes, maybe 10? If you took your time. And again, if you are given that opportunity, read it slow. This is not a race. As a matter of fact, the judge will probably pre-warn you, hey, my clerk, Tiffany over here, she's a bit of an old gal. She doesn't quite go as fast as she used to. So just talk really slow so she can type this stuff in accordingly. And you'll find when you actually slow it down and you actually have a moment to breathe, you'll actually feel a lot less stressed. You're in control here, loved ones. You are being put into possession of some incredible knowledge right here. And you should feel a little bit relaxed. You should feel a little bit, yeah, okay, I know this stuff's pretty technical, but because I've been listening to it for almost a month now, some of this stuff is actually starting to make sense. And don't worry if the judge ever asked you, what did your number 6 mean here, Darren? Where you're saying that, you asserted that some of these following facts were true and to the best of your belief and knowledge, and that you claim to be the surety and you're claiming here to discharge some liability that was attached to you, and now you're essentially claiming to be entitled to an assignment of securities. What do you mean by all that? Well, again, this is where you're going to be called upon to crayon that answer. Well, Your Honor, at some point, I realized I made a mistake, and to remedy that mistake, I did some homework. I did some digging. And to the best of my ability, I came up with all this, Your Honor. And I know that this thing is a negotiable instrument. And I know I can perfect my interest in it by writing a bunch of stuff on it. And then I can give it to you so that you can interpret that and you can put it into the possession of the party who should have had the thing from the beginning. There's a crayon version of all this shit you're looking at right there. That's literally all it was. Again, this yellow is for you to see the specific language that's hiding in the background here. This stuff is incredible. If you want to shorten up your paperwork and take this right out, go ahead. But all you're going to do is make the clerk go, and someone's going to have to go reference all this shit right away. Again, but that's their job, so don't feel bad. Let them do some work too. Again, this is what the trustees are for. The petitioner also asserts the following facts are true as relates to my assignment of interest under a private appointment duly made by myself and material to my cause or case under Section 36 of that Law and Equity Act again, assignment of debts and choses in action. Assignment of debts. That's what we're looking for here, loved ones. You can't assign the debt until you make it more valuable and you perfect it. You had to show up, do something to it. That gave you the power to now go give it to somebody else. You actually have to have the thing before you give it to someone. The petitioner believes the following to be true and that the information is derived from the doctrine of merger and is also indicated by Section 12 of the Law and Equity Act. Merger. There is, see, when I alluded to earlier in the affidavit or in the petition here where I said where the merger happened, not at law only. Well, here's why. There is no merger by the operation of law only. You had to bring equity in to merge these two things. If you only were dealing with the common law or the at law or the public legal side, you only got half of the picture. And if you've only got half the picture, you've only got half the story. And if you've only got half the story, you've only got half the title. And if you've only got half the title, you've only got half the interest. And if you've only got half the interest, you're only doing this, you're only doing half of what we need to. We literally had to merge that sucker with our equitable interests. Once that happens, this thing becomes whole. Those legal interests now fall off. They get attached to the new trustees and they're happier than shit, believe it or not. What's the legal basis for all this? Well, the petitioner prays for and relies upon the following reliefs, that should have been plural, under Section 39 of the Law and Equity Act. If rules of equity and the law conflict, equity prevails. Again, this is almost cut right out of the Judicature Act. Again, you've all loved ones have heard me say this before. The Judicature Act, 1873 to 1875. Generally, in all matters, here, they added this part. Not particularly mentioned in this act. See how you have to have equity, Isaac? What did that just say? Generally, in all matters, not just the ones we're talking about here. That means everything. So they're literally they just blew the door wide open for us right here. In which there is any conflict or variance between the rules of the equity and the rules of the common law with reference to the same subject matter, the rules of equity shall prevail. The fact that we're bringing this into our affidavit and our petition and our deed, it's in our order. All the judge can do, especially when no party shows up to say, yeah, we can't oppose this, Your Honor. We have no standing to even get involved with this. That would be coming out of the public trustee's mouth. That's it. The judge knows this already, which is why we're actually making this petition. Okay, you know what? I'm just going to do it right now. Up here somewhere, petition to the court. I'm going to say right about here. Let's do this. It's kind of important. Where was that? Oh, okay, factual basis. We're an affidavit in support of a notice of your petitioner's title and demonstrating a conflict with the rules at law where it is appropriate to stay here. We did that. The petitioner also relies upon the following relief under Section 4 of that same act. Equitable relief for the plaintiff or petitioner. Now, again, I put the actual wording in here, so technically this should be in yellow, just so you kind of maintain the flow here. Again, if you want to include this, go ahead, take it out if you like, but as long as you have an idea what this stuff was. So, again, all this is saying that a plaintiff or a petitioner claims to be entitled to an equitable estate or right or to the relief on an equitable ground against a deed, you're going to get it, is what this is saying. So continue. The petitioner relies upon the following relief under Section 7, that the judiciary will take notice of my equitable estate. There, you just forced them. You can't deny it now. Like Bryce was on the public side the other day, it was like, the judge didn't want to admit it, didn't want to take it into evidence, didn't want to acknowledge it, didn't want to recognize it, didn't want to grant any relief for it. You lock him down with this particular one. Again, this should have been yellow as well. And then here, we're done. Material to be relied on. So now we're just going to, the dates and the numbers of your affidavits, describe them a little bit here. And again, the petition will take about 20 minutes. And then the judge is going to ask you anything else. So this is pretty hardcore, loved ones. This is, again, as hard and technical as pretty much as it's going to get. This is pretty red. There's not much yellow in here. There's no green at all. Tomorrow morning, I'll take a crack, though, at stab it and take a poke and try to green this up a little bit. But I strongly encourage you to also do it. And then send me what you come up with and share it on the group here so that we can all learn really quick. Because again, I would much rather put you all, loved ones, in a position where you can actually say, yeah, Your Honor, I did have a hand in creating this. I did this and this and this and that and that and that and that and here and there. That was me. The rest was other contributors. However, I do have a good understanding or a good grasp, Your Honor, of what the hell's going on here. And because we're motioning for an injunction, because we're motioning for a receiver to be appointed, a receiver and an injunction can both be appointed through interlocutory orders. So I'm going to suggest on the affidavit, did I have interlocutory order in the commencing title? Notice of affidavit in support of petition. Petition for It's in there somewhere. You might want to put interlocutory order, where I think I had appointments, vesting orders, and injunction. But go ahead and put interlocutory right there somewhere. Okay, loved ones, that is going to get a good chunk of this done for you. Bryce is going to take this hardcore version and he's going to roll with it. He's going to be on pins and needles waiting to see the crayon version of it tomorrow morning anyway. We'll get something up, but he's got a busy day with printing and getting things done and in envelopes and showing up to the court and getting all this affected. But see, again, this is where all of us also have an incredible head start here. The schedule, I will also post tomorrow a version of it, what the schedule looks like, maybe what your exhibit looks like. Bryce already has all that done, so he knows how to do it. The exhibit stamp is simple. It's just like, this is exhibit A1, attached to an affidavit made by such and such on such and such a date. And then the court clerk stamps it. That's how they bring evidence into court, through exhibits. Schedule is pretty easy. Yeah, we can roll the deed out in the next day or three. And yeah, we're sitting pretty good here, my friends. So I think we can wrap that up for now. I'm going to just basically close down and keep going with some of this stuff. Let you chew on all that. Be excited for a simpler version tomorrow. And yeah, we're continuing. I hope you understand and see the significance of why we need to go to the court and have the judges help here, because there is so much going on. This is mind-boggling. I know I said earlier that judge in Alberta here said, oh, it's not the fancy language, it's the clarity. Okay, well, you're looking at almost all the substance. If I missed a 1 or 2 or 3 components, it doesn't matter. This thing's still going to get the job done. How do we get rid of the fancy language and just make this a little bit more clear? Well, again, I'm looking forward to having some feedback from your loved ones. But take your time. Again, no rush. Doesn't matter whether, if don't feel like we need this tomorrow. No, just at your leisure. Go do some research on your own. Cut some of this stuff up. See what Gilbert's book says. Go check out what Pomeroy says. You might have different tweaks and different versions of things, but it's getting you involved. It's getting you eyeballs on and boots on the ground and hands in. This is where your confidence is going to come from, loved ones, so that when you're standing in front of the judge, or if you're on the phone in your kitchen talking to him, whatever, trust me, that's just about as nervous as being in court. It is. I shit you not. There's just some weird energies here because we know how important this is. And we know we are the ones that created this problem. So, Your Honor, I'm really just coming here to show you my clean hands, show you what I've done, expressing some interests. trying to get this thing put into the possession of the right party. That's literally all I'm trying to do here, Your Honor. Okay, loved ones, with that, I think we can close this up. Look forward to tomorrow. And again, tomorrow, same time, I'm going to start putting things up earlier in the day, probably on the Telegram chat. And I'm still going to try to show up for the 1 o'clock Zoom to just continue with this, and probably the 7 o'clock Zoom. So same time, same places. Today, I was just a little bit crunched because I had to formulate and get a lot of stuff done here today. So I think that will do, loved ones. And until tomorrow, peace. Love you all.